Welcome to Weekdays Live. This is CJ Holmes, founder of Homeowners for Justice, and your host for today's show. And today is a really special day. We've got several of our experts on the line ready to answer your questions. I've lined up a bunch of questions. Some people have sent them in. Some are going to call and ask and discuss. They've sent documents. So the topics on the show are going to just be all over the board. We're going to go where it takes us, and we're going to get answers, the best answers that we have in the country right now. Thank you so much for watching. And I wanted to point out that today the conference call is not available for callers. If you're going to have a question, please email it to me with your name, phone number, and the question and any document, and email it to cjholmes@cjholmes.com, and we'll call you. Gail, my wonderful staff person, will get you on the line and line up callers with these questions. And the documents I'm going to be able to get to all the participants quickly, and then I'll show documents on the screen so that hopefully the discussion will make sense to you. Thank you so much for joining us, and we look forward to getting to that. But just before we bring our guests on, I've just got to point this out. As I said, every day there's something going on in the news. And good old Marcy Kaptur, she happens to be a progressive congresswoman, one of the longest females in Congress. I think she's in her 14th term. But look at the bill she has sponsored. As of January 4, 2013, she's introduced this bill to the House of Representatives, and it's H.R. 189. Let's flock to support this, to prohibit Fannie Mae, Freddie Mac, and Ginnie Mae from owning or guaranteeing any mortgage that is assigned to the mortgage electronic registration systems, or for which MERS is the mortgage of record. We certainly haven't heard about it. This was in January 4th. Now it's over 6 weeks later. I don't want to talk more about the bill at this point. I'm sure our guests, they may have some comments about it, which we can range into when that time comes. But this is really helpful that we have authorities and some senators. Now we've got her and Elizabeth Warren, and then there's a couple of others. Let me just pull that up here. These are connections. Let's connect with these people. Elizabeth Warren, Marcy Kaptur, and I'm sorry, Warren is from Massachusetts, I believe. William K. Black, who's not in the government right now, but certainly has some media attention and following. Neil Barofsky, the same. Sherrod Brown, who's in the Senate, Ohio Democrat, and Chuck Grassley from Iowa, Republican. We're getting both sides, and like I say, it's not R&D. It's about the people versus the banks and vested interests. And then, of course, local Democracy Now! Groups. This is the core. This is the grassroots. So let's connect the best we can with that. One other thing I wanted to bring to your attention in the news before we get started with Q&A, which may take, we'll go as long as people have questions. The U.S. Department of Justice is probing J.P. Morgan over Bear Stearns mortgage products. So we're starting to see some activity. I am confident that some of this is coming because of the Untouchables, these other news media presentations where they've put the Department of Justice on the spot saying, what is going on? You haven't even investigated? We've contacted all these people, and they're all insiders. They've all told us all this stuff about fraud and forgery, and the DOJ hasn't even contacted them. So what is going on? I believe, like we've said before, the wind of political opinion is shifting. We need to capitalize on that and push it. So today, I'd like to invite our guests, James McGuire, Voice of the People, Joe Esquivel, mortgage compliance investigators, a securitization expert, Alvie Campbell, and he made these titles up, the Tamale Man. And welcome to my tree limb, and that's because he feels like he went out on a tree limb for the people. And we so appreciate, thank you so much, guys, for joining us. Can you say hi?
Thank you for having me.
All right, thank you guys for volunteering. So the first issue that I'd like to ask you about real quickly. Do you guys have any comments you'd like to make on the things we just talked about on the show? One would be the bill, H.R. 189, and the other would be the Department of Justice probing J.P. Morgan over Bear Stearns.
I'm going to take that one, CJ. This is James.
Perfect.
When you're dealing with the HR bill and so forth, if they're going to pass a law to allow what has happened to happen, they should have passed it already. Now, that gets back to our Congress and all of this, and what did we vote for them to sit in Congress and ask what happened? These are the same people that passed the laws that allowed it to happen. Let's vote them all out of office.
Well, what's fascinating to me is that it like you said, it's taken so long, and now we've heard nothing about this. And also what's interesting is that it's basically progressives that are coming in for the people. That's what I'm seeing. There's a few Republicans or Democrats that are supporting efforts. Other than voting them all out, which may or may not happen. Any other suggestions anybody has? Guess not. Okay. So I believe we as the people, a group of us, we need to connect with these folks that are stepping up. There's a few of them, and we need to give them all of our support as possible. So the next question, what about the Department of Justice probing J.P. Morgan over the Bear Stearns loans? Any feedback about that from you guys?
About time.
Do you think they'll be successful?
Depends on whether the intangible money and all this this intangible wealth is sufficient to keep the people into a servitude that they don't belong in.
Right, and
it all depends on whether the Spirit of God is followed or not, or whether we're all going to follow the path of Satan.
The other thing I've noticed, and I'm looking at this article, I've got it up on the live stream right now. It just says they're looking into it's a civil investigation, not criminal. They're looking into whether Bear Stearns altered due diligence information. In other words, did you lie to third parties? And it states that the investigation is in its early stages. Okay, when was Bear Stearns done? This was 2008, right? So now it's taken him 5 years. That's insane.
Would calculate out.
Right, and there's still.
Now to understand this, what has been created is so complex.
Right.
That there's a lot of people out there that are just absolutely ignorant, including judges, a lot of lawmakers. A lot of people are just ignorant as to how complex this is. And if you go back and look at the principle that this was all put together, it's under the principles of Sun Tzu, which was written 1,000 years ago, and the Banks Manifesto released by Charles Lindbergh while he was in the Congress, pretty well shows that you follow the principles, divide and conquer. That's, the United States has, if we're not divided, we shall win, and the people right now are so divided, they don't know where to go because of ignorance. Now, lawmakers and a lot of our judges they're so ignorant, and if they do sit there and believe that a lot of the people are deadbeats, they don't realize that when they go to that aspect with what's been created, they're in actuality condoning tax evasion when you get down to the depth of it. And therefore, this country does not have the tangible money to pay its debt because of all this tax evasion that they scream and holler that, we can slaughter around taxes here, we can slaughter around taxes there. Everybody needs to pay their share. Everybody.
Right. And I totally agree with this concept. It's divide and conquer. They have chopped up, they have divided both the lenders the issues, the owners, where those notes theoretically were supposed to be in which mortgage-backed security, and then they've chopped up the investors, they've chopped up the notes and the income streams into all these tranches. They've hidden who those investors are. They've written it so that the investors of the securities and the owners of the notes, the people, can't get together or find each other or negotiate, because they're right in the middle, splitting everybody up. And this has been a real challenge. I agree with that. And of course, what we're trying to do is to bring the pieces back together, to educate both the people and our officials. I totally agree with you. This is so completely out of the understanding, even the concept. I've said this before. I speak to a prosecuting attorney, and he doesn't understand what an impossible beneficiary designation is. And that was my description.
CJ, you're at a point now that we need to just go ahead and address Susan's document, and let's start from there, because we're going to walk into a unique world that most people are going to become learned very fast.
Exactly, and I think Susan's on the line right now. Let's see. Susan, is this you?
Yes.
Perfect. Okay, you're on the air, and I have not said anything about your issue. The callers do have, Joe and James and Alvie, they have your document. So please share your question, and away we go.
Sure. Yes.
Go ahead.
Great. Well, what I want to know is how can I find out that according to this audit, five of the 6 of the 15 different pools that my loan was placed into have been paid off. But how do I know how they were paid and who paid them? So there's that one question. Then I do have another question as well. And it has to do with the bank paying my property taxes for a number of years and how that would impact my standing.
Okay, if you want to stay on the line, go ahead. Joe, James, who's going to answer this? Oh my goodness. Oh my goodness. I'm sorry. Just a minute, guys. I told you I don't know how to do the phone. Just a minute, I got to call back into the conference.
Sorry.
Just a second.
The number you have dialed has not been recognized.
Seven.
This service is provided. Access code accepted. There are 3 participants in this conference. Please announce yourself.
I'm sorry, this is CJ, and I just pressed her to have her ask the question, and I'm sorry, I forgot to put you guys on hold and make this a conference. So I'm going to try this again, and just a second here. Okay, Susan, you there?
Yes.
Okay, I think I'm going to get you all on conference. So if you don't mind, ask your questions again. Just a minute. Okay, you guys are there, right? Hello?
But you
Okay.
have voice on live stream.
Okay.
Susan here.
Okay, perfect. Joe, James, and Alvie, you there?
Well, we're here. I'm here. This is James.
Okay, I think I was able to work the phone. I so apologize. Okay, so Susan, start with your question again, please.
You've got audio in your live stream, do you?
I can't tell. It looks
Yeah,
like
I have
it.
my
Okay, you do. I
Okay.
get it now.
Okay, perfect. Okay, Susan, go ahead.
Okay, great. Well, according to this little audit I have here, my loan was broken into 15 different
Stop, Susan. We're going to explain some things real quick before you sit there and say another word about what you think it is. Hey, Joe,
shows the intangible obligations that were created by an entity for which
I'm having a real hard time
and
hearing.
Joe, can you speak up, please?
I said this screenshot, okay, was created for investors to invest in. All right, the screenshot shows the intangible obligations. So depending on the amount of risk the investor was willing to take, would depend on what tranche they would invest in.
Right.
Some of these tranches are principal only, some are interest only, some are principal and interest. That's what we're looking
Okay.
at on the screen.
Okay, now Susan, to answer your question, by looking at this screenshot and this one document that you submitted that's a CFLA document, first of all, I'm not impressed with CFLA at all. Never have been. There's a lot of things that just this screenshot and what's on this one-page document tells me is we're looking at a 2006 trust, which identifies the tranches in it, the screenshot does, but your mortgage note was never negotiated to that trust. If you go back and look at your original security instrument, usually it's in covenant 19 or 20, you're going to find in there that it most likely says they're going to sell the note or an interest in the note along with this security instrument. That interest in the note is an electronic, intangible payment stream, and they needed to give the illusions that the investors were secured intangible creditors, so they're going to have this tangible security instrument follow this intangible obligation. It's the intangible obligation is what you're seeing in this tranche pool. But when you're looking at can the tangible security instrument follow the intangible obligation? No, it cannot. That's the principles of Carpenter, as far back as Carpenter versus Logan. The security follows the note. Your mortgage note is most likely endorsed in blank. It resides with a custodian for the benefit of this trust. And if you understand how the laws apply to it, it's nothing but personal property. There were no enforcement rights given to the trust because it was never negotiated with them. And you most likely have MERS involved.
Oh, absolutely,
And with all these endorsements in blank, you lose agency relationship.
Right.
So, Susan, what's your question about this then?
Well, according to this document here, it states that six of the classes have been paid. My question is, who paid them? How were they paid?
Who cares?
I don't understand
Who
that
cares?
statement.
It's an intangible contract created by the account debtor to the intangible obligee. So if it's a credit defaulted swap that paid off the investors, it doesn't matter.
Okay.
Right. And in other words,
The
Susan...
contract, and it really has nothing to do with was the tangible obligation paid. It's only the intangible obligation that the investors bought, and that intangible obligation is secured by the payment stream that's secured by your paper note and your paper security instrument.
And I believe, all of you guys, that this ties back into that whistleblower claim that we talked about just yesterday, because they did not actually assign these notes into these securitization trusts. They just took the payment streams. That's what James keeps talking about, the intangible. Then the fact of the matter is they violated IRS code to be a pass-through REMIC, real estate mortgage investment conduit. And so I believe all the owners should be filing whistleblower claims, because the fact is the notes never did get into the trust. And so that's why these people have no authority to foreclose. And I'm sure there's other reasons, because I'm, again, pretty superficial in my responses. James and Joe and Alvie, they just go into such depth, which is great. But basically, James, like James says, it doesn't really matter who paid it off. It's either an insurance company, a credit default swap, something like that. Now, what can she do with this, James? Anything?
For one thing, with what I'm seeing right now, and if she's got an endorsement in blank on the note, and the security instrument was never properly perfected according to her state's law and so forth, you're looking at potential securities fraud. You're looking at tax evasion because that remit is no longer a pass-through tax.
Right.
The implications are serious.
And so, James, what should she do about that, other than like the whistleblower claim that we talked about yesterday? Anything else?
Educate herself so that she knows what the real facts are, not what a bunch of people sit there and assume what the facts are. What's being presented in the courts today and a lot of things, people are just grasping at everything they can. They don't know what's real or not. They won't take time to look at, here's what the statutes say. You are not in compliance with the statutes, even though this case law over here, the banks, and I can't say that all banks are bad. I'm just going to say the people within the banks are bad. They're going to come up and sit there and say, well, we got this case law that says this and that. But that case law is not brought up on the correct arguments.
And so...
And the situation is, this country is founded on laws and statutes.
Right.
Use the statutes. What do the statutes say? Were you in compliance with the statutes? Yes or no? In the hell with case law.
Right. Because case law is just on a specific case, which may or may not be exactly like what you're doing. Probably not. And besides, now, is there something she can do with this that doesn't require going into court? Is there some way that she can use an audit like this to save her house from foreclosure, for example, or to fight fraudulent foreclosure?
Well, I would say, not knowing all the specifics, I would have to say that the original note still has a security instrument attached to it, a public records, and anybody else that's trying to make claim to that, maybe consider a Fair Debt Collection Practice Act trying to collect somebody else's debt.
Right.
Because, I mean, from everything it is, you're looking at a default of the intangible has been declared. Where did the originating lender tell the homeowner, you're in default? Because it's never been properly negotiated, and the security instrument has never been assigned of record to subsequent unidentified entities that don't appear on the note. So you got the wrong person trying to collect.
Right.
That.
Okay. Yeah, no, it was originally taxed by Metro Cities, which is no longer in existence. And it was definitely
So
a
the best thing I can tell you right now is get a hold of Joe Escobar.
Yes. Okay.
Hi, Sharon, real quick. Basically, what I'm looking at on this document is that it's just a cursory information. That's what the document's providing you, right? Instead of telling you what was to be done, what was done, and what was not done, all right, specifically, statutorily wise, that's not what it's telling you in here. You need to know the exact information on your specific loan, your specific state statutory requirement. That's what you need to have in front of you. That's not what this document is showing.
Now, Joe, is that what you do audits, right?
We do analysis.
Okay, analyses. Okay, and so your analysis would actually give all the information you've been talking about.
Correct. Sharon has specific state statutory requirements that must be met, and that's what she needs to attack. As James said, we know what the intent was within her own documents that were provided to her at closing. Right? And we know what statutes to go with because, again, as it's stated many times, we need to attack everything in parallel. The note, the security instrument, and the security interest, as they all pertain to separate laws. So that's how she needs to fight it. Everything needs to be fought in tandem.
Okay.
And then, Susan, you had another question about
I
property
did.
taxes.
Obviously we've been in default. We went into bankruptcy to stop the sale, and we got a rescission shortly after that. So we're currently on a holding pattern, but I know they're just raking up the fees, so I know what they're gaining.
Okay, in the bankruptcy.
Pardon?
Okay, I got to stop it. In the bankruptcy,
Yes.
how did you list your promissory note?
As a secured asset, because I didn't know any better. No, I did list it as secured because at that point I didn't know any better. And I have spoken with my attorney, who's reluctant to go back and revise. And I don't know, at this point in time, since then I've heard about quiet title and all the, and I'm educating myself about all the known infractions on this thing. Of course, there's robo signing. Of course, there's this, that, and the other thing that are incorrect about it, according to California state statutes and federal law. So I understand
And
how
what I'm trying to tell you is, in
Yeah.
bankruptcy, when they file the proof of claim, if it's not the originating identifiable person on the note, then they cannot prove themselves of record to be a secured party. And under bankruptcy rule 3001 subsection delta, they have to do that. And if they can't do that, the proof of claim should have been denied.
So the originating person has to be the one claiming?
No, I didn't say the originating person. I said the person identified as the last person identified on the note. It's also a secured record. They are the only ones that can file a proof of claim under Rule 3001 subsection delta of the Bankruptcy Code.
Right.
Anybody else file, claim they're a secured creditor and not able to comply with Rule 3001 subsection delta D, maybe it's considered fraud upon the court.
Well, they're claiming because they assigned. They do all these assignments. Is that how they're getting around it?
What was assigned?
The corporate assignment of trustee and the assignment of...
You're talking in the intangible world.
I don't know.
I don't know what's that. You're dealing with the laws that apply to your promissory note and your security instrument, and then you've got another separate set of laws that apply to the intangible payment stream that's been created and the security that secures it. And they are trying to, in a lot of cases, apply this intangible law to apply to the tangible law so that they can circumnavigate state requirements. Can't happen.
Sharon, you can amend your schedule for $26 yourself. If your attorney won't do it, you can do it. You probably have it listed on Schedule D. Again.
I'm sorry, I'm having a hard time hearing you, but I'll listen to the replay, so continue on.
He's saying, Susan, that you can amend your schedule for $26.
Okay.
Even if you can't get the attorney
Put
to do
it as a unsecured, and list my home as a unsecured.
To tell you how to list it, you have to look at the facts and list it according to what your facts are.
Correct.
So how does she? Okay, guys, you got to understand that you understand what you're saying, but the people don't even know how to start to do that, and their attorneys aren't helping them. So can you just be a little bit more explanatory about how she can do that?
I told her to contact Joe Escobar.
Yeah.
Yes.
Okay, so Joe can help you.
Because there's a nonprofit involved, and they do have private investigators and so forth, and they can bring in certain facts that she may not be aware of.
Right. So the point is...
It's so complicated, the average person in a 1 hour question and answer is not going to comprehend it.
Right. Well, I understand that. I do have another question, and it has to do with the bank has been paying my taxes for a number of years. Is that going to give them a leg to claim?
I'd say goody two shoes. If they want to pay for something they're not obligated to pay for, whoopee-doo.
Love it. Okay.
Is that going to make any difference in her bankruptcy filings or her lawsuit?
If you apply the statutes, I'd say no. I mean, that's like somebody paying your telephone bill for you. Telephone company don't care who pays it.
Right, right. And they couldn't claim those as damages because they didn't have to pay them in the first place.
Right.
Okay, good to know.
Okay, so Susan, definitely you got to get somebody that really understands how to structure the lawsuits. James says to me all the time in emails, when there's a ruling against anybody in favor of MERS or something else, the fact is the lawsuits weren't filed correctly. That's what he's constantly stating. And I believe this really is a major issue, and that is the people don't understand. We don't. And neither do the attorneys, and neither do the judges. And so the banks knew this and have capitalized on it. So we just have to fight back. Thanks.
Thank you very, very much. I will be calling Joe.
You're welcome, Susan.
Thank you. Now, guys, I have a question sent in by, this is about the MERS issue. Let me see. Just a sec. Oh, just a minute. Okay, back online. I had to put you on hold to hang her up. Here's a question that somebody has said. I've had a predatory loan on my home and have been attempting to sue the mortgage broker and lender for over 5 years. Do you think that that's what he should be doing? Now he's run out of money. The attorneys have taken his money. What if somebody has, which we know 60 million people have predatory loans, what do you recommend is a cost-effective step for them to do?
First of all, I'd find out what lender they're trying to sue, whether it's the proper party or not. And if it's not the proper party, as the facts would prevail, then why in the hell did the attorney take all this money and try to sue the improper party? I would consider going after the attorney's bond, if he's got one.
All right, so both of those actions the people need help to do that. How do they find a good attorney to help them like this? Any ideas or suggestions?
Joe Escobar.
All right. Joe, can you just tell us what
This is the system we're setting up.
And this is the point, Joe. What kind of monies are people looking at to get lawsuit help or whatever help they need from you? Can you just give me a range of?
It depends on the situation for that particular client.
Okay.
Right. Many of the clients, all they want to do is just come to some sort of settlement. If they can get a principal reduction, if they can get a payment that they can afford at an interest rate that is true and accurate to today's times.
Okay, I'm going to interrupt. They want to find a fair value that they can pay for.
Correct.
Right. Okay. And that, Joe, that's what you're talking about as a settlement.
Correct.
Okay.
So again, it depends for each client. We need to see, are they NPV positive? Net present value. Can they afford, if they get this settlement, can they afford it? And we need to find out realistically where each particular person is for their unique situation. They're all similar, but yet they're all different.
Right. Which is another real tough point. That they're all similar, but they're all different.
Right, but we need to sit down with each person and say, what is it you're looking to do? Okay, where are you at in today's fight? All right? Have you lost your home? Are you still in your home? Are you in a lawsuit? And so before you just give a generality answer to everybody, I mean, again, we need to look at specific conditions for each person.
Right.
Now, the other factor here is if the obligor, the homeowner, is in doubt, am I paying the right person? Make their payments to the registry of the court, but don't stop making your payments.
That puts you in a stronger position.
That shows good faith that you're willing to offer up compensation for a fair purchase.
Right. Right.
The right thing to do.
Right. Now, I'd like to move into another.
Anything to do. Render unto Caesar what's Caesar, render unto God what's God. If Caesar is entitled to the payments, tender the payments.
Now, what happens if the lawsuit is dismissed because, or the bank cannot take those payments because they don't have standing? Then does the owner get those payments back?
That would be, if I was an owner, I would have to file a motion with the court and ask the court to make a determination as to where those monies go to. If there is property bought, there is something owed to somebody. Let the court make that determination who gets the money.
Right. Okay. Another question. Here's somebody that sent in a lawsuit. I forwarded that to you guys. It's about MERS. MERS not being licensed to do activity in the state of California. And this is a question from the email that I've received. A potential smoking gun about MERS. Here's a copy of a decision in which MERS is involved. The U.S. District Court for the Eastern District of California acknowledges that MERS is not or was not licensed to do business during the applicable time frame. And so, are you aware of that? Is that something others can use? Can you comment on this?
Well, if MERS is trying to sit there and claim that they're operating in place of California recordation laws and acting as somewhat of some type of an agent that needs to be registered in California, but in the intangible world, MERS doesn't need to be a record in California because they're going to fall under the national exemption.
Okay, so you're saying that because they fall under federal law, it doesn't matter, basically. Is that the summary?
As long as they're dealing strictly in the intangible world, yes.
Now you guys are getting a little faint, so I don't know what that's about. Now, another question that he brings out is that they're talking about the order of the recording of the documents. Do things have to be recorded before the notice of default or not? And my current understanding is in California is basically assignments have to be filed before the notice of default, but trustee substitutions do not. I don't know if that's accurate. Can you comment on that?
I would say that you would have to have all precedents procedures in place before you invoke standing. And if the state requires that all assignments be in place to assign rights, which are the rights to have standing also, before you can file a notice of default, that's fine. And if it requires a notice of default before one can file an appointment of substitute trustee, those two I think could be interchangeable, because if the true secured tangible obligor creditor had the rights, he can substitute the trustee at any anytime he wants post or pre the notice of default, if that's what I understand the question.
Yes. Yes, my reading of the statute is that as long as the trustee substitution is filed before the trustee sale, then it's okay. But not the assignments, that the assignments have to be filed before foreclosure starts, before the NOD.
Yes, you would have to assign the rights of the security instrument attached to the tangible note to the party that's trying to foreclose. And if those assigned rights aren't with that party to have them to be the secured tangible obligor creditor, then they don't have any rights to foreclose.
Right. And that's
Now the other aspect of this is, let's just say that party, maybe they didn't have all the security instruments assigned to them correctly, and they ended up with the note in their hand as bearer paper. Well, what's the value of that bearer paper that they're holding? Now you've got to go back and look and see how much of the intangible has been ripped out of it to see what the value of that note is.
right. Right. Now, I've been using that basically, if you will,